Welcome back to Career Post. Today we will see about GDS Conduct and Engagement Rules 2020, and that will be useful for IPO examination, PS Group B examination. This will be a class for you. First off, there are three categories under GDS, that is Gramin Dak Sevak means first one is the branch postmaster or BPM, as you all know, and assistant branch postmaster, that is the new designation given under this rules. GDS other than BPMs and working in BOs, they are called as, those who are working in BOs, they are called as ABPMs, and those who are working in SOs or departmental SOs and RMS, those GDS other than BPMs are called as Dak Sevak. So you have to understand the difference. Then comes the members of the family includes wife, child or stepchild of such a sevak, and whether residing or not. So residing with the GDS is not a problem for wife, child and stepchild. And in relation to woman GDS, the husband should reside with her and should be dependent on her. Then only it will be construed as family. And members of the family includes any other person related whether by blood or by marriage to such sevak or to the such sevaks of wife or husband and wholly dependent on the sevak. So those who are dependent on the sevak, they are included in the family, but they will not include whom the legally separated sevak or the stepchild or child who is no longer in any way dependent on the such sevak. They are not included in the family. And or of those custody, the custody whose custody the sevak has been deprived by law. That means if the court says that this child does not pertain to you by virtue of law or after a court's decision, then they are not dependent, and only widow and dependent daughter-in-law, they have come under the family member. And coming to Rule 3A of the GDS Conduct and Engagement Rules 2020, the terms and conditions of engagement of GDS we will see here in this 3A. That is, the maximum duty period is 5 hours, we know, and retirement age is 65 years, and adequate means of livelihood is required, and a declaration of other sources of income is also necessary. Here you should remember that other sources of livelihood means it should not be any business that is detrimental to the Department of Post or as well as IPPB. That means LIC or any other insurance business from Tata Insurance or those things should not be done by the GDS that are detrimental to the Department of Post as well as IPPB. And transfer on administrative grounds, vigilance grounds and on in public interest is also possible for a GDS under this Rule 3A. And a sevak shall be outside the civil service of the union. This is also given in the rules. And a sevak shall not claim to be at par with the central government employees. So this is a different line. They mean to say it cannot claim at par with the central government employees. And other terms and conditions of the GDS engagement are the residence. There is one more condition, a residence condition. You should reside in the post village delivery jurisdiction of the PO within 1 month. This 1 month is important after selection, but before engagement shall be mandatory for a sevak. That means once he has got selected, prior to selection he need not be there. Once he was selected, after selection within 1 month he has to take residence in the post office village or delivery jurisdiction within 1 month after selection, but before the engagement shall be mandatory for sevak. Failure to reside in the place of duty of for the GDS BPM and within the delivery jurisdiction of post office for other Gramin Dak sevaks after engagement shall be treated as violative of conditions of engagement and liable for disciplinary action under Rule 10 of Conduct and Engagement Rules requiring removal and dismissal. So this is very, very important. Residence condition is there. Within 1 month of selection, once he is selected, he should he should reside in the PO village, and before the engagement. That means by the time he comes to the duty, he should be in the residence only. That he should reside in the post office village. Otherwise, if he is violating, action can be taken under Rule 10 that may entail removal or dismissal also. So that much severe it is. Then post office shall be located in accommodation to be provided by the GDS BPM suitable for use of post office premises. So BPM has to provide for the accommodation of the post office in the BO village. However, where accommodation is provided for the post offices by state government or central government or local government or panchayati village, the same will be used for the post office premises. One more point is that combination of duties of the sevak shall be permissible. That means whenever there is a the other other GDS is on leave, combination of duties, that means this duty should also be done by the BPM. That is also possible in the rules. And now we will see about the recruitment process of GDS, that is the online engagement process of GDS. The eligibility criteria for engagement to Gramin Dak Sevak posts is age limit is 18 to 40 years as on the date of notification, that is there. This you should remember, and age relaxation is provided for certain categories. EWS not SC, ST, OBC will have 10% reservation, but EWS will not have any age relaxation. However, and SC, ST will be having age relaxation of 5 years. That means normally under UR it is 40 years is the maximum period as we have seen. So SC, ST they will be allowed up to candidates, they will be allowed up to 45 years, 40 plus 5. OBC will be 40 plus 3, 43 years. EWS there is no relaxation, and persons with disabilities will be 10 years relaxation. That means 40 plus 10, 50. And PWD plus SC, ST, if they happen to be PWD and as well as SC/ST, 15 years is provided. That means 40 plus 15, and PWD plus OBC is 13 years. So 40 plus 13, that is 53 years they will be allowed. One more condition is that relaxation in the upper age limit is subject to the condition that maximum age of the applicant on the crucial date shall not exceed 56 years. Earlier we have seen here PWD plus ST/ST is SC/ST is 15 years, 15 plus 40 is 55, but sometimes it may go beyond 56 also. So they have given the cutoff time. This is important. 56 is the cutoff date. A relaxation of age limit subject to condition that the maximum age of the applicant on the crucial date shall not exceed. Crucial date. This is important. Crucial date shall not exceed 56. One more condition is that age relaxation not applicable for person with benchmark of disability blind, as in place of blind. Candidate with low vision have been identified by the directorate letter number. So that is also there. And educational qualification, it is all we all know SSC pass, that is secondary school examination pass certificate, that is 10th standard with passing marks in mathematics and English, that is having being studied as a compulsory or elective subjects. Both mathematics and English should be there, and conducted by any recognized board of school education of the government or Indian state or state union territories shall be mandatory. Educational qualification for all approved categories of GDS, that is BPM, ABPM or Dak Sevak, as prescribed from time to time. So this is 10th class is important, and Maths and English they should pass. And one more condition is that compulsory knowledge of local language is important for recruiting a GDS under online engagement. The GDS should have studied the local language, that is Telugu, Marathi, Tamil, whatever it is, Malayalam, whatever it is, Hindi. Local language at least up to 10th standard as a compulsory or elective subjects as declared by the state government as per constitutional provisions relating to 8th schedule of Constitution of India as prescribed by the department from time to time. So this 8th schedule and local language up to 10th standard they are both important. Why this local language condition was imposed for a BPM means if a person from a Bihar is selected in Andhra Pradesh or Telangana, they may not be knowing the language or the Kerala person candidate is selected in Bihar, that Malayalam language he will be acquainted with, but he may not be knowing Hindi, the one who are familiar with in the local language. That will be a problem for doing his daily activities or even for the procuring the business. So that is local language is imposed. And one more condition is basic computer training. These are all the conditions for GDS engagement, and while notification these conditions will be given. The candidates of all approved categories of GDS referred to in above will have to furnish a basic computer training certificate of at least 60 days duration. The 60 days is important. 60 days computer training certificate is required from a training institute run by central government, state government, universities, boards, private institutions also allowed. And this requirement of basic computer knowledge certificate can be relaxed in cases where the candidates have studied computer as a subject in matriculation or 12th or other higher education level. In such a case, a separate certificate will not be insisted upon. That means normally basic computer training for at least 60 days is required for GDS engagement. However, this certificate should not be insisted whenever the candidate has studied computer as a part of the subject in 10th or inter or any engineering or whatever education, higher education qualification it may be. In such a case, you need not ask for the separate certificate. That certificate itself will be sufficient, and they should submit that certificate. Next, residence. The condition of residence shall apply as stipulated in Rule 3A7. This is important. Rule 3A7 is the residence condition, very, very important condition. Under Conduct and Engagement Rules 2020, the candidate must provide the accommodation for BO post office within 1 month after selection, but before engagement, as we have seen. And unless an accommodation is provided by other agencies like Panchayat and local entities. And cycling, knowing of cycling is also a prerequisite for condition for all GDS posts, including the BPM or GDS. Why? Because in combination of duties, the BPM may also have to ride the cycle for delivering letters if the contingency arises. In case of candidate having knowledge of riding a scooter or motorcycle, that may be considered as knowledge of cycling. So you need not insist on cycling for those candidates who know riding or motorcycle. What is required? There won't be any test or test drive, but only as declaration is to that effect is required. Adequate means of livelihood. That means the condition of adequate means of livelihood shall apply as stipulated in Rule 3A. 3 of GDS Conduct and Engagement Rules 2020. However, this condition shall not be a prerequisite for candidates for the purpose of applying the GDS post. That means at the time of applying post, you need not provide any adequate means of livelihood. But on selection or selection there too, for selection it is not required, or for applying it is not required. But once the candidate who is only one candidate who is selected has to comply with this provision, prescribed condition within 30 days after selection but before engagement. So residence should be within 30 days after selection but before engagement, and even the adequate means of livelihood other than this BPM post should also be within 30 days after selection but before engagement. These both two are same, 30 days or 1 month. The GDS will also have to ensure that she is having adequate additional means of livelihood during the period of engagement till discharge. So it is not only within 30 days after selection, but it should be continued till the discharge. That means until his retirement after 65 years, he should have that adequate means of livelihood other than the BPM post. So that is why earlier they have given these. Earlier they used to give the GDS posts as honorary posts to the teachers and local current incomes and those all things. Now this has become a part of engagement or recruitment. So now also the department considers it to be a honorary post. So it is provided for adequate. They have to provide for the adequate means of livelihood other than the BPM. Furnishing a security. On an engagement of GDS, the person or so engaged shall be required to furnish a security, that is surety, in the manner such may be prescribed from time to time. Recently, this 25,000 or 1 lakh the security used to be taken. Recently this has been dispensed with by the department of furnishing the security. Very recent announcement that was. And fulfillment of other conditions, the terms and conditions of engagement to GDS post shall apply to stipulated in the rules of GDS conduct rules modified from time to time. And on engagement as GDS, the person so engaged shall be required to furnish security. This is removed, I told. Now we will see about the time related continuity allowance. This is called the for GDS there will be TRCA instead of they don't call it as salary, they say it as TRCA, time related continuity allowance. In respect of GDS engaged on or after 1/7/2018, the initial fixation of TRCA will be done on the first stage of level 1 of the respective category. So this is also there. For BPMs, minimum TRCA of there will be two levels, level 1 and level 2 for BPMs, and ABPMs also level 1 and level 2, depending on level 1 and level 2, depending on the minimum TRCA for 4 hours. If it is 4 hours, it will be level 1. If it is 5 hours, it will be level 2. Level 1 BPM will be 12,000, and level 2 BPM higher scale will be for 5 hours. Level 2 it is 14,500. ABPMs will be 10,000 for level 1, and level 2 it is 12,000. The method of engagement is online engagement. Earlier it used to be offline. Now it is online by logging into appost.in. You can apply whenever there is it is notified. Exemption of fee for applying GDS post. Male UR, that is unreserved, and OBC EWS, they have to pay the requisite fee of 100 rupees or whatever it is as per the notification. But all female, all SC/ST, all PWD candidates, there won't be fee for them while applying for the GDS post. And BPM profile, you all know that all the work relating to SB, RD, TD, MIS, all these things will be done. And I have given, have made a video about the GDS BPM or all the profile thing in the BPM video. Just watch it so that you can understand. That is a 1 hour video with the comprehensive details relating to GDS. If you have not watched it, just watch it. And the work performed for IPPB will not be included in calculation of TRCA. So IPPB work will not be included in workload of the for calculation of TRCA, since the same is being done on incentive basis. So incentive is given, so it is not included. He or she will also be required to do marketing, organizing, melas, business procurement, and any other work assigned by the IP, ASP, SPOs, SSPOs, and the IRM, etc. There is one more thing is that voluntary discharge schemes are there. On completion of 20 years of engagement period, voluntary discharge scheme is available for any GDS. He can opt for voluntary discharge. Voluntary retirement, instead of retirement they call as discharge, instead of salary they call as TRCA for GDS. And there is one more option is that on medical grounds after 10 years also, on medical grounds it is 10 years, it is normal grounds it is 20 years. We will see detail. GDS voluntary discharge scheme. First scheme is without reason. After 20 years of service, putting 20 years of service, proportionate benefits will be given. And scheme 1 with no age restriction, 3 months notice should be served to the divisional head. The GDS can give a 3 months notice to divisional head, and dependents are not eligible for compassionate appointment in this case. If a voluntary discharge scheme, if a person goes on voluntary retirement, in such voluntary discharge they call, dependents will not be eligible for compassionate appointment. That you should remember. Second scheme is also there on medical grounds. Service should be minimum 10 years of service should be there in GDS, and proportionate benefits will be paid, and no age restriction is there, and on body or mental illness which permanently incapacitates the GDS, in such a case they can go on discharge. And in the scheme 2, that is the medical ground scheme, certified by the medical authority or civil surgeon, and divisional head directs the GDS to appear before the medical authority, and dependents not eligible for compassionate appointment in this case also. So this should be kept in mind. Next one is the powers of engaging authority. The engaging authority can award penalties under Rule 9, and in no case the authorities who are appointed awards penalties under Rule 9 shall be lower in rank than the authority who originally engaged the GDS. That means, for example, in case of one division where earlier it was a SP division, that means the division is manned by Superintendent of Post Offices. SSP division, that means it is manned by Senior Superintendent of Post Offices, and the GDS was recruited by SSP, and later on the division has been downgraded to SP division, that is controlled by SP instead of SSP. So in such a case, the GDS who is there will not, the SP cannot exercise this penalties over the BPM for this reason. Why? Because he should not be the authority appointed to award penalties under Rule 9 should not be lower in rank than the authority who originally engaged. Who originally engaged is SSP, so SP cannot exercise. These circumstances also will be given in the normal CCS conduct rules also. under Article 311. And pension and severance amount. Pension, no pension is there for GDS, and entitled to GDS will be entitled to GDS gratuity or severance amount, or if severance amount is not there, SDBS, that is Service Discharge Benefit Scheme is there. If he has enrolled in that scheme, he will be given either SDBS or severance amount as per the case may be. Next one is the leave. GDS, they will be given a paid leave at a rate of 20 days in a year, and 10 days for every half year without accumulation, and as may be determined by the government from time to time. Here half year, every 1st January they will give 10 days credit, and 1st July also 10 days credit will be given. Total 20 days of paid leave will be given. That means while proceeding on leave, the GDS will be given the normal TRCA that is given in the previous month. Where a Sevak fails to resume duty on expiry of maximum period of leave admissible and granted to him, or where a, say suppose if the Sevak fails to resume duty after expiry of the maximum leave of 20 days granted to him, then where such a Sevak who is granted leave for a period less than the maximum admissible or under these rules remains absent from duty exceeding the limit, then he shall, unless the government in view of exceptional circumstances decides, be removed from engagement after following procedure laid down in Rule 10. So this is very, very important. If the GDS fails to resume duty after 20 days, or even if he is granted only for 7 days and he has proceeded beyond that 7 days, he can be removed from engagement under Rule 10 also. So this is very, very important. And the engagement of Sevak who has not already rendered more than 3 years continuous engagement from date of his engagement shall be liable to be terminated at any time by giving a notice in writing either by the Sevak to the engaging authority or the engaging authority to the Sevak by a special order to the Sevak. So there will be a termination process also. Two types will be there. One is if the service is engagement of service is more than 3 years, then inquiry will be conducted, and based on the inquiry, the disciplinary action will be taken. But if the service is less than 3 years of continuous engagement, he can be straight away terminated by giving a notice in writing by the appointing authority, or the GDS also can ask for a termination by giving a notice. Either way, it is possible. The notice period shall be 1 month notice, and even the GDS can be terminated forthwith, immediately also he can be terminated. In such a condition, what you have to do, some equivalent to the basic TRCA plus DA should be given to the GDS by sending a money order, or whatever period may be falling short of 1 month, that amount should be paid. Where the intended effect of termination has to be immediate, if they want the GDS engaging authority want the termination to be immediate, in such a case 1 month's TRCA plus DA shall be remitted to the GDS in lieu of notice of 1 month through money order. When engagement of GDS is terminated under the rule, she shall not be eligible for GDS gratuity or severance amount, etc. for thus 1 year or 2 years or 3 years. In such a case, he will not be eligible. This is important. And now we will see about the penalties that shall be imposed under Rule 9 for GDS. Under Rule 9, there are 5 minor penalties and 4 major penalties. We will see one by one. Minor penalties, first one is censure. That will not have any impact under any circumstances. But this censure, giving censure will warn the GDS that it is a recorded statutory penalty that will be recorded in his service rolls. Next one is the second punishment penalty that can be given is debarring from PA or postman or MTS examination less than 3 years. So under this penalty, he can be debarred from appearing for the PA or postman or MTS examination not exceeding 3 years. It should not exceed 3 years. Then the other penalty is punishment is minor penalty is debarring from the MTS seniority cum fitness less than, that is not exceeding less than 3 years. So he can be debarred from getting the promotion of MTS. GDS can be debarred from getting the promotion of MTS by virtue of seniority, not exceeding 3 years. 1 year or 2 years or 3 years they can give. Next one is recovery of pecuniary loss to the government by negligence or breach of orders. So, if any GDS has caused any loss to the government or any loss to the government, say for example, if any GDS has broken that device, Tarpan device or whatever it is. In such a case also, if it is this recovery of pecuniary loss to the government or negligence of breach of orders, if any order is given that you should take escort of the GDS BPM for carrying the money, and he has not he has violated and he had himself gone, and there is a theft that has occurred in such a circumstances, that can be recovered from the GDS. So these are some examples I am giving. In such a case, that pecuniary loss, that loss has sustained by the government will be recovered from the GDS. And the fifth one is the withholding of annual increase in TRCA without cumulative effect less than 3 years. So that means increment we call, that is called here for GDS they call it as annual increase. This annual increase can be withheld, that means increment can be withheld in TRCA for a period less than 3 years. More than 3 years you should not give. All these three cases where this debarring from MTS, debarring from examination, or debarring from seniority, or withholding of annual increase should be always less than 3 years. Should not exceed 3 years. 1 year, 2 years or 3 years they can give, but not 4 years or 5 years like that. Okay. So these are the 5 minor penalties. Take a screenshot. Now this you can see here that is given as a description. And pecuniary loss for recovery under Rule 9(4) can be imposed fully without any restriction. So any amount can be recovered without any restriction. So it can be lakh or 2 lakhs or whatever it is, it can be recovered. Next one, let us see the 4 major. We have now up to now we have seen the 5 minor penalties for a GDS. Now we will see about the 4 major penalties under Rule 9 for GDS. The first one is the reduction to a lower stage in TRCA less exceeding 3 years. That means more than 3 years. If the GDS reduction to a lower stage, that means if he is in level 1, level 2, it can be reduced to level 1 also. And it should be more than 3 years. If it is less than 3 years, that is different. If it is more than 3 years, that is a major penalty. And the second penalty, major penalty, is compulsory discharge from engagement. That means we will give compulsory retirement like that. And in such a case, he will be compulsory retired and compulsory discharge from engagement, and SDBS GDS gratuity will be given, and there won't be any cutting. Okay, whatever the eligible up to that many proportionate amount they will be, he will be given. Then the third one is removal from engagement. That means removal of service or removal of engagement here, and not to be a disqualification for future engagement. So by any person, any GDS who is removed from service or who is removed from engagement, it is not a disqualification for future engagement. He can be engaged in elsewhere in the government. Dismissal. If a GDS is dismissed, it is a disqualification for future engagement in the government. In the government, if a person is dismissed, he should not be engaged again. So that is a removal and a dismissal. That difference is there. Removal means he can be engaged again. Dismissal means he cannot be engaged again under government. So these are the 4 major penalties. Take a screenshot, and this is given in writing. Okay. Next point is that procedure for imposing minor penalty. So whenever the engaging authority proposes to give a minor penalty, in such a case the GDS should be informed in writing, and a representation can be sent by the GDS if he wishes so, and basing on the representation only a penalty can be imposed by the engaging authority. And Rule 10b says about the procedure for imposing major penalty. In a major penalty also, you should be informed him of the right in writing, and a representation can be taken from the GDS, and an inquiry should be compulsory conducted, invariably conducted, mandatorily conducted in case of a major penalty. One IO PO will be appointed. One IO is the inquiry officer and PO is the presenting officer. Presenting officer will be presenting the case of the case for the department, and he is as good as a lawyer for the department in this case. And this GDS also can engage a AGS, that is assistant government servant, to defend his case. So, and inquiry authority will be an ASP or IPO or any cadre. So it will be in such a case that inquiry will be conducted, and a record for proceedings shall include the a copy of intimation to the Sevak of the proposal to take action against him. So whenever GDS, whenever action is to be taken on a GDS, a copy of intimation of Sevak that the proposal to take action against him should be sent to him, and a copy of statement of allegations, that means the articles of charges, along with the list of evidences in support of thereof communicated to him, and he should be informed that these are the 1, 2, 3 allegations made against you, and these are the rules that you have violated. Those things should be mentioned, and list of evidences also, there will be witnesses also, that also should be informed him, and his representation should be there, and the records of inquiry proceedings along with the inquiry report of the engaging authority or the inquiry officer, if any, appointed in case where the formal inquiry is necessary. The inquiry officer also submits his report after the inquiry with the witnesses, with the GDS, with the presenting officer, and all the inquiry will be conducted, and final report will be submitted to the engaging authority. That also should be there while giving the proceedings. And final proceedings means giving the punishment order. At the time of giving the punishment order, all these things should be kept in mind. And the representation of the Sevak on the inquiry officer's report. Once the inquiry officer has submitted his report, that will be sent to the GDS, and GDS has to comment on that inquiry officer's report, and he may submit a representation. That representation also should be taken into account while giving the final punishment order, that is called the proceedings. Finding of engaging authority in respect of allegations. Even after the inquiry officer's report is given, the engaging authority also can accept the inquiry officer's report, or he may also reject his report, reject the findings of the report, and he may give his own findings also. And finally, he should discuss all these points in the final order of imposing penalty, and he should issue the order imposing the penalty and copy given to the all concerned. So that is the process in case of a major penalty. Major penalty inquiry is compulsory. Okay. In minor penalty also, if the GDS asks for inquiry, it can also be conducted, but it is not mandatory. Inquiry has to be conducted even if the GDS accepts the charges in cases where major penalty is to be imposed by the engaging authority. So even the GDS accepts the charges also, generally inquiry will be conducted. For the purpose of inquiry, holding inquiry in such cases is primarily to give the GDS adequate opportunity to defend himself or herself. In case the charge is accepted by him unconditionally, there would obviously be no need for an inquiry for imposing major penalty. So if he has accepted unconditionally, then there is no need of inquiry. But in normal cases, generally, even though he accepts unconditionally, also they will in real time, in practically, they will conduct the inquiry and then only award the punishment. Why? Because in court, if they go to court, this conducting of removal of the employee without conducting the inquiry, the courts, they will pass remarks, and they will set aside the order also in some cases. So normally they conduct inquiry before giving a major penalty. Procedure for imposing penalty after a discharge. They even after a discharge also, if the penalty should be given, that can be given. It is similar to that of review petitions to the President of India. That means the petition will be sent to the President of India, and a decision will be taken by the President. And no appeal lies against such a decision. And once this decision has been given by the President of India, there shall be no appeal. No appeal can be filed by the GDS. Procedure for disciplinary proceedings after discharge. Say suppose if a GDS has been discharged from service after 65 years and if we want to give a disciplinary proceedings after discharge, it is possible, but there is one condition is that inquiry should be conducted and reasonable opportunity should be given to him, and one more condition is that it shall not be in any way event which took place of more than 4 years before institution. So after retirement, whenever you want to give a proceeding, disciplinary proceedings against GDS, say suppose right now, this case should not be more than 4 years before case. Then only you can give. If it is a 5 years case, means you cannot give disciplinary proceedings after discharge. And rule 11 says about the provisions of rule 10 shall not apply. In which cases this rule 10 inquiry shall not be applied is where a penalty is imposed on Sevak on the ground of conduct which has led to conviction on criminal charge. Say suppose if he is convicted on a criminal charge by the police and the court, in such a case the inquiry is not necessary. Where the inquiry empowered to dismiss or remove a Sevak is satisfied that for some reason to be recorded by the authority in writing, it is not reasonably practicable to hold such inquiry. If there are some certain conditions where this holding of inquiry is not possible, that reasons should be recorded by the engaging authority, and uh, and inquiry cannot be held, and he can be straightaway action can be taken. And the third condition where straightaway action can be taken without inquiry is where the president is satisfied that the interest of security of a state, it is not expedient to follow the procedure prescribed in that rule, and engaging authority may consider the circumstances of the case and may such orders thereon. That means in case of interest of security is involved and it is not possible to conduct inquiry based on the interest of security, then also it can be taken. Rule 12 defines about the put off duty of a GDS, where IP and ASP of a subdivision is not engaging authority. An order made by them under sub rule 1 shall cease to be effective on expiry of 15 days from the date of such orders unless earlier confirmed or cancelled by the engaging authority or the authority to which engaging authority is subordinate. Say for example, the recruiting authority for a BPM is the divisional head or SP or SSP, and for a GDS Gramin Dak Sevak or Dak Sevak, ABPM is the subdivisional head, or in some cases it is the LHG SPM. In say suppose if IP or ASP, if who is not engaging authority for the BPM is has given an order to put off the GDS BPM, in such a case that order of putting off the BPM has to be confirmed, either confirmed or cancelled by the engaging authority within 15 days. If that is not done, if it should be ratified by the engaging authority, and if it is not done within 15 days, then that order will be nullified. That will not have any effect. Okay. So it should be immediately ratified. Ex gratia is nothing but the subsistence allowance for a departmental employee. We call it as subsistence allowance. At the time of suspension is equivalent to put off in the GDS, and ex gratia is equivalent to the subsistence allowance that is granted for a departmental employee. And this ex gratia will be 25% of TRCA plus DA that will be granted at the time of during the put off duty. That is the allowance that is granted at the time of put off duty. After 90 days, the competent authority to review the ex gratia paid to the GDS. Once 90 days has gone by in put off duty, then the competent authority has to review the ex gratia paid to the GDS. Either of these two can be done. One is that it can be increased, ex gratia can be increased by 50% of the ex gratia paid for the first 90 days. What is that ex gratia paid for the first 90 days? 25% of the TRCA plus DA will be paid. Say suppose if ex gratia is E, say suppose ex gratia is E, then ex gratia can be increased by 50% of E. So that means that 25 by half, that means 12 and a half plus 25, that is 37.5% of TRC or DA. It can be raised. Okay. And if reasons for extension is not directly attributable to GDS, if there is no problem with the GDS and reasons for extension of put off is not because of the GDS, reasons are not because of GDS, then it can be increased by 50% of the ex gratia, and it can also be decreased by 50% of ex gratia in the first 90 days what is given if the reasons for extension is directly attributable to the GDS. It is because of the GDS who is not uh, supporting the inquiry or supporting the smooth conduct of inquiry or whatever may be. In such a case, it can be decreased by 50% of ex gratia paid also. So it should be reviewed after 90 days. And the payment of compensation for put off for the put off duty shall not be subject to furnishing of a certificate that the GDS is not engaged in any other employment, business, profession, or occasion. See here in the departmental case, in departmental employee case, the department employee who is under suspension should not be engaged in any other employment or business or profession or vocation at the time of suspension. But here, unlike departmental employee, here the employee, the GDS employee who is under put off, he need not furnish the certificate of unemployment. Okay. In that case, they have to furnish. A sevak who has been absconding or remains absent unauthorizedly and is subsequently put off duty shall not be entitled to any compensation as ex gratia payment. Who is absconding, he will not be given put off duty because it is a pure loss. Already he is absconding, so that should not be given. Minor penalty ends with if a minor penalty ends with if a major penalty ends with a minor penalty. If a major penalty ends with a minor penalty, then full TRCA will be paid for put off duty also. If dismissal or removal is set aside by court, then the deemed put off from the date of dismissal or removal until further orders if inquiry is proposed. Say suppose dismissal or removal is set aside by the court, then the put off, deemed put off from the date of dismissal or removal until further orders if the inquiry is proposed. If an inquiry is proposed by the engaging authority based on the set aside orders of the court on the dismissal, or if the GDS is removed or dismissal and the court has set aside these orders, that means it has turned down these orders. In such a case, the GDS will be automatically deemed put off from the date of dismissal or removal until further orders if the inquiry is proposed to be conducted. Any payment made under this rule to the sevak on reinstatement shall be subject to adjustment of compensation already paid as ex gratia. Say suppose if the court has given the order that if the GDS has been reinstated after a certain days of put off, then any payment under this rule by virtue of setting aside the orders, then the salary will be, full salary will be given, full TRCA will be given for the entire period, but that compensation or the ex gratia that has been paid under put off duty should be recovered, should be adjusted. Then only full payment should be paid. Appeal. Under Rule 13 and 14, appeal can be made by the GDS on the penalties that are imposed by the GDS engaging authority, and it shall be done within 3 months of receipt of the order of penalty, and so it should be appeal should be made within 3 months on receipt of order of the penalty. And Rule 15 that appeal should be on his own name. It should be appealed. It should not be by 2 or more people like that. Combined appeal cannot be made, or with unknown persons also it should not be made. It should be by his own name, and it should be separately it should be made, and it should be completely it should be made, and no disrespectful words should be used in the appeal, and it should be addressed to the appellate authority, and it should have all the material evidences in support of his case. And Rule 16 is submission of appeal, how it should be submitted. Every appeal should be submitted to the authority which made the order appealed against. So this appeal should be addressed to appellate authority, but it should be submitted to whom it should be submitted. It should be submitted to the authority which has given the order on which he is going for appeal. So the 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 ordering authority, the punishment giving authority can withhold the appeal if rule 15 is violated. That means under rule 15(1) it should be on own name. If it is not given on own name, or if it is not given separately, or if it is not complete, or if no material evidence is given, or if it is disrespectful, or if it is not addressed to appellate authority, in such a case of deviations, what it can be withheld, and it should be returned to the appellant and can submit within 1 month again. In such a case, it can be submitted 1 month. This 1 month is important, and delay without reasons should be given, and delay without reasons, and repetition without no new facts. If he is time and again submitting the appeal without any new facts, then also it can be withheld. Say suppose if the authority has withheld it, it should be informed to the appellant the reasons behind withholding the such cases, and list of appeals withheld should be reported quarterly with the reasons to the appellate authority. Under Rule 19, there is a revision, provision of revision. Any authority superior to the authority passing the order of punishment, PMG within the region or CPMG within the circle can revise the penalty by modifying or changing or enhancing the penalty. So revision, it is revision power is there. That means changing the penalty given by the order by the punishing authority. It can be made by the authority superior to the authority given by the PMG or CPMG, or if it is the penalty is given by the IP, the divisional head has that power of revision. But there are certain conditions. No revision before 3 months from the order of penalty. That means during the appeal period you cannot revise the penalty. There should be provision for appeal, then only revision can be done. Before 3 months it cannot be done, and no revision after 6 months from the order of penalty. After 6 months also it cannot be done. When it can be done? After 3 months, before 6 months it can be done. During that 3 periods, the order of penalty can be revised, and accept with the order of the PMG, CPMG and government. But with the powers of PMG and CPMG and government, they can do. No application to revise an order made on an application for a revision or order passed or made on revision shall be entertained. So once that is revised, and in such a on the revision order, no application to revise an order made on an application for revision or order passed or made a revision shall be entertained. Once that is revised, no order for revision can be again asked for. Rule 20. The President can review any time at any time when new evidence has come now. So the President of India has the powers to review the penalty made by the authorities, and review petition can be made within 2 years based on the new evidence. Say suppose within 2 years the GDS can submit a review petition to the President based on the new evidence, and this 2 years is important. The powers of the President under this rule shall be exercised by a plenary board comprising of member P and member O, or comprising of such authorities as may be delegated from time to time. This is also important. So who will exercise the powers of President? Member P and member O, plenary board. Next one is Rule 21. Now these are the conduct rules. Now we will start conduct rules. Basically, till now we have seen the engagement rules. This is conduct and engagement rules 2020. First one is every sevak shall at all times maintain absolute integrity, and that means honesty and integrity, and maintain rule 21(1) is maintain absolute integrity. 21(2) is maintain absolute devotion to duty. That means his duty he should do with absolute devotion. And third one is rule 21(3) is do nothing which is unbecoming of a sevak. That means unbecoming of a sevak means unbecoming of a government servant, like that. In the CCA rules we will CCS conduct rules we will see. Here it is unbecoming of a sevak. So these 3 rules are very important, even in for a practical thing or for examination purpose. You should remember these numbers also from right now. 21.1, 21.2, 21.3. These rules, three rules, they will be quoted in addition to the normal departmental rulings that they have violated in that at the time of giving a framing charge sheets. So this is important. See, for example, if a GDS has done a fraud, then 21.1 will be quoted. He has not maintained the absolute integrity. And say suppose if he has not maintained any records or some BO account or BO summary, BO account or any other journal as required by him, it is nothing but he has not maintained devotion to duty. And if he has participated in politics or political things, it is nothing but doing nothing which is unbecoming of a it is becoming of unbecoming of a saver. So we will see one by one. Rule 21A is a promptness and courtesy. No sevak in performance of his official duties act in a discourteous manner. So in discourteous manner, he should be courteous to the members of the public or any other official also, and he should not act in a discourteous manner while doing duty. And in his officials dealing with the public or otherwise adopt dilatory tactics or willful cause delay in disposal of work assigned to him. So no sevak here, no sevak it is there. He should not do this one. No sevak should delay the dilatory tactic should not be adopted or willfully cause delay to the disposal of work for the public. That is there. Then rule 21B is a prohibition of sexual harassment of working women. No Gramin Dak Sevak shall indulge in any act of sexual harassment of women at workplace, and every Sevak who is in charge of workplace shall take appropriate steps to prevent sexual harassment to any woman at such workplace. These are the conduct rules. And 21B here, there is one more point is that workplace means it includes the organization and so many things are there, and even the dwelling place, that means living place or a house also comes under this rule 21B. That means any department, organization, undertaking, establishment, enterprise, institution, office, branch or unit which is established, owned, controlled or wholly substantially financed by funds provided by directly or indirectly by the central government, or hospitals or nursing homes, any sports institution, stadium, sports complex, venues, anything, any place visited by the employees or GDS arising out of that during the course of employment or engaging, including transportation provided by the employer for undertaking journey, a dwelling place or house. All these things includes the workplace. So in detail you can see in the rules also. And rule 22 is taking part in politics or elections. No sevak shall be a member or otherwise associated with a political party or organization which takes part in politics, and shall not take part in or subscribe in aid of or assist in any other manner in the political movement or activity. So in political movements or activities or joining in political parties, these things should be avoided. Even money should not be given. You should not assist or you should not aid or you should not go with them. This is there. And one more thing is that it shall be the duty of the every sevak to endeavor to prevent any member of the family from taking part in or subscribing in aid or assisting in any manner in any political movement or activity which is tends directly or indirectly be subversive of government as by law established, and where sevak is unable to prevent the member of the family from taking part, subscribing or aiding or assistant. In such a case, he should report to the government. That means not only himself not participating in the political activities or assisting or aiding, he should also prevent his family members also from participating. He should prevent his family members also from participating in the political activities. If he is unable to do that, he cannot control his wife or husband. In such a case, he has to report to the government immediately. And in say taking part in politics and elections under rule 22, if any questions arises whether the political party, whether a party is political party or any organization is politically connected, then the decision of the government will be final. And one more thing is that no sevak shall canvass or otherwise interfere with or use his influence in connection with or take part in election to the legislature or local authority. So he cannot canvass also, he cannot interfere, he cannot take part in election, he cannot influence others also. and is sevak qualified to vote, he can exercise vote, that's all. And one more thing is that he should not give any indication of the manner in which he proposes to vote or has voted. That means he cannot say, I have voted to so and so, or I am going to vote to so and so. Either way it is not allowed, and that is a violation of rule, and action can be taken if that is done. And a sevak shall not be deemed to have contravened the provisions of rule by reason only that he assists or the conduct of election in due performance of duty imposed him or under law for time being enforced. Say suppose if a GDS is asked to perform a duty as ordered by the election commissioner, so to assist in conducting of election, then that he can do. So only two things he can do: he can vote, he can assist if he is ordered to assist only by the government or the election commission. Only these two things can be done, other things he cannot do. And one more thing is that display of the sevak on his person or vehicle or residence of any electoral symbol shall amount to using his influence in connection with the election within the meaning of the sub rule. That means he cannot keep a flag of a political party on his vehicle, or he cannot carry himself, or in the residence, or any symbol. It should not be there for the GDS sevak. That is against their rules. Rule 23 is about strike. He should not participate. No sevak shall resort to or abet a form of a strike or coercion or physical duress in connection with any matter pertaining to his conditions of engagement or engagement of the sevak. So strike is not allowed, and participation of strike will not only result in the deduction of a TRCA, it may also constitute a break-in service of break-in engagement also. That means incitement, violence, sabotage means damage. These things are not allowed, and GDS who resort to action of the above kind of violating Rule 23 of GDS conduct rules and disciplinary action can also be taken. And these conditions are only illustrative and not exhaustive, and only clarifies the position in respect of the practices which are often resorted to at present. GDS who is absent from engagement hours for participating strike shall not be entitled to draw TRCA, DA, bonus, paid leave, etc. And strike period shall not be adjusted or regularized by any grant of leave also. So during the strike period also it cannot be adjusted as leave also. And if it is specifically ordered by the competent authority after show cause notice on account of incitement of violence and sabotage, the strike period will be result in a break-in service, break-in engagement. The strike period would not qualify towards engagement period for absorption of GDS against MTS posts, which is done on seniority basis. At that time also, this break-in service will be a problem for the GDS while considering for his promotion to the MTS cadre. The strike period would not qualify towards engagement period for GDS to appear for the LDCE also. That period will also be deducted while counting for the LDCE for appearing the examinations of postman, MTS and mail guard or PA, etc. The above action as per 127 may also be taken without prejudice to the disciplinary action that may be taken against GDS. That means in addition to not allowing all these, not allowing him for appearing examination or not qualifying for MTS posts and all these things, cutting the salary, apart from this, disciplinary action also can be taken if they participate in strike. That is what it is given. Rule 24 is about criticism of government, and no sevak shall in any radio broadcast or in any document published in his or her own name, anonymously or pseudonymously, or in the name of other person in communication, make any statement that is he should not give adverse criticism against central government or state government, or he should not give any statement that is embracing the relationship between the state and central government, and he should not give any statement that is that will embrace the relations of the state or central government with any foreign state. So this there is a exception for this rule, that is in any case in official capacity of this sevak, it is given if any statement is given under the due performance of duties as ordered by his superiors, then it can be done. Then evidence before the committee or any authority. As per no sevak shall accept for the sanction of the government give evidence in connection with the inquiry conducted by any person or committee or authority. So evidence should not be given by the GDS except for the following. He should not criticize the policy also at the time of giving evidence also. But inquiry for the departmental inquiries or judicial inquiry or inquiry before the government is allowed. Okay, these are three exceptions for evidence before a committee. 26 Rule 26 is unauthorized communication of information. So GDS should not that is in possession of him any in good faith of duties assigned to him or communicate directly or indirectly the official document information. He should not part with. He should not give the official document or information to anyone without that are available with him to anyone until unless he is ordered for. Quotation by Sevaka of or from any letter, circular, office memorandum, which he is not authorized to have access and who is not authorized to keep in his personal custody or for personal purpose shall amount to unauthorized communication of information within the meaning of this rule. That means he cannot quote any other head of the department or president or any other letter or circular that is not supposed to be with him. In such a case also it will be constituted as a violation of rule. Insolvency and habitual indebtedness, Rule 27, a sevak shall manage his private affairs as to avoid the habitual indebtedness. That means if a person GDS is having habitual debts, that means habitual debts, he frequently borrows money from other persons and he will be indebted. Habitual indebtedness is not allowed. And a sevak against whom any legal proceeding is instituted for recovery of debt due from him or judging him as an insolvent shall forthwith report the full facts of the legal proceedings to the government. In such a case, he should report to the government that he has been some recovery has been made. If a recovery is made by the court, that should be informed to the engaging authority by the GDS. And if any, if he is termed as insolvent, that also reported to the engaging authority. 28 Rule 28 is vindication of acts and characters of sevak. That is, no sevak shall accept with the previous sanction of the government have recourse to any court or to the press for vindication of official act which has been subject to matter of adverse criticism or an attack of defamatory character. Here that means without the government's order or he cannot go to court or press for the official aspects, and nothing in this rule shall prohibit the sevak from here vindicating. That is, vindication means defending his private character for his under private capacity. That means if he wants to go to court because if there is a litigation with him with his neighbor on a land case, in that such a case he can go for the or any some defamatory suit has been filed by a neighbor or like that. In such a private character, he can go for that. He can vindicate. He can defend his case. But normally, it should be. He should have previous sanction from the government. Next one, canvassing of non-official or outside influence, other influence. Rule 29. This is important rule. No sevak shall bring or attempt to bring any political or other outside influence to bear upon any superior authority or to further his interests in respect of matters pertaining to his her engagement under government. That means political influence or outside influence should not be brought on the superior authorities to get his work done. That means for a transfer or for any other work, you should not give influence by outside persons or political influence. That is against rule. Canvassing means that is against rule. Rule 29A is a prohibition regarding engaging in any business detrimental to the business of post office or IPPB. So this Rule 29(1)(a) provides for the GDS will not engage in any activity which is with any outside agency which would be detrimental to the business or interest of the post office or IPPB. See here we are doing PLI or PLI insurance business. If the GDS is engaging doing any LIC business or any Tata or any other business that is not given approved by the department, such is detrimental to the business of the post office or IPPB. In such a case, action can be taken under this rule. And Rule 30 is nothing but interpretation. If any question arises relating to interpretation of the rules, it should be referred to the government and decision of the government will be final. Delegation of powers Under this rule, the government by general or special order direct any powers exercisable under these rules except the power under Rule 30. It shall be exercisable by officer and specified under. So the rules are here given here. For the here it is given the description of the service, Gramin Dak Sevak or BPM or whatever it is. Engaging authority, it is deputy superintendent of the post offices or divisional head. And appointing authority competent to impose penalties, minor, major, it is given, and appellate authority also given. So for GDS generally it is BPM, it is a divisional head, is the engaging authority, and he can impose all the penalties, both minor and major. For IP it is minor he can impose, and appellate authority will be the for a divisional head it will be the director postal services. Okay. Then Gramin Dak Sevak, it will be a senior postmaster or divisional or the inspector of post office or ASP, and all penalties can be imposed, and the divisional head will be the appellate authority. RMS also it is like that only. And some provisions also we will see right now. Children educational allowance CEA is possible for GDS up to 6,000 per year per child of GDS. For the two eldest surviving children it can be given. And office maintenance allowance is given for BPM who can avail 500 for standard office rent and 250 for non-standard office rent. If a standard accommodation is provided, 500 will be paid. If non-standard, it is 250. Leaves to 20 paid leaves, as we have seen, credited at 10 each in January and July on 1st. And maternity leave will be granted for the female GDS for 180 days for 2 children. And miscarriage and abortion 45 days maternity leave will be granted in entire career irrespective of number of surviving child. And maternity leave can be combined with the paid leave. Maternity leave cannot be debited from the paid leave. And the divisional head is competent to grant maternity leave for female BPM, ABPM or Dak Sevak. It is not the subdivisional head in case of ABPM, that you should remember. DH is competent for maternity leave for all GDS cadres. And leave without allowances for GDS sanctioning authorities, we will see. BPM it is 60 days by the subdivisional head, and 61 to 180 days it is divisional head, and ABPM 90 up to 90 days subdivisional head, and Dak Sevaks up to 90 days subdivisional head or head of the office if he works in office which is a sub-appointing authority. And ABPM and Dak Sevaks it is 91 to 180 days it is the divisional head will grant. And all GDS beyond 180 days the regional PMG or DPS will grant. No allowance will be paid to GDS during leave without allowances. And now we will see about GDS combined duty allowance. BPM for delivery or mail conveyance work 45 rupees per day will be granted. Maximum will be 1170 per month. For BPM for delivery and mail conveyance 90 rupees per day and 2340 per month maximum. And ABPM is BPM work. If ABPM does a BPM work 75 rupees per day and 1950 per month is the maximum ceiling. And ABPM or Dak Sevak for additional work of another ABPM or Dak Sevak 45 rupees per day, maximum is 1170 per month. So now we will see about the GDS Transfer New Rules 2021. Males for male 2 transfer chances in entire GDS career it can be given, and for female 3 transfer chances in entire GDS career it can be given, and apply for maximum of GDS 10 posts for a transfer in order of preference in one division at a time, and can apply for after 1 year at any time during the year. And refusal for transfer in one chance availed. That means if GDS refuses a transfer and it does not withdraw within the request within 15 days, then the chances is construed as availed. Okay, refusal of transfer means it is one chance availed, but he can withdraw the transfer request within 15 days of application, then his chance will be alive. And mutual transfer is allowed, and minimum 1 year service is required for considering the mutual transfer also. So these are the transfer rules. Take a screenshot. And the competent authority for approval of transfer is within the division it is divisional head, outside the division but within the same region it is regional head, outside the division or region but within the same circle it is a circle head, and outside circle is circle heads of both circles. And manner of GDS transfer is level of transfer if it is within the division, the authority is the head of the division, and action is that is to be taken by him is issue of transfer order straight away. Within the region, head of the division and head of the region, head of the division will forward the application to regional office. Head of the division will issue order, transfer order. If it is within the circle, the head of the division will forward the application. Circle head will issue order. Out of circle means head of the division will forward application outward, and head of the circle outward will obtain the consent from the circle concerned, and head of the circle inward will convey the consent to the circle concerned, and head of the circle outward will issue transfer order. This is the process. And circumstances of GDS transfers are given here. BPM level 1, BPM, then such a case transfer is allowed up to the level of BPM level 1 in TRC at slab 2, and BPM level 1 can be transferred as ABPM GDS level 2 postal and RMS in the same TRCS slab, and BPM level 2 can be transferred to the BPM level 2 in transfer in TRCS slab 3, and ABPM GDS SAVX level 1, ABPM Doc SAVX level 1 in TRCS slab 1. And for ABPM and Doc SAVX in level 2, they can go for ABPM Doc SAVX in level 2 in TRCS slab 2, and even they can apply for BPM level 1 in case of TRCS slab, provided that GDS has to make accommodation arrangement for managing the BO as per standard prescribed for BO and fulfilling the conditions of education qualification, and even computer certificate should be given, and before joining the BPM level 1 he has to undergo prescribed training for the BPM. And ABPM and Doc SAVC from postal to RMS and vice versa in same TRCS lab is allowed, and Doc SAVC in RMS and BPM and ABPM Doc SAVC in same TRCS subject to providing standard accommodation fulfilling the education qualification and computer certificate as above. These are the circumstances of a transfer. So this is all about GDS conduct and engagement rules. How do you like the video? Post in the comment section, and for more marks and higher ranking, subscribe to Career Post. Thank you one and all.